Hired appearances for the township. Have a seat, make yourself comfortable. All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to be addressed immediately, especially with the official lines and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
Well, it's covering all the official lines.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed? Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
I just have a mistake straight to me telling you you didn't give a shit about what I had to say.
Okay, hold on. Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers just cheating green telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Crucell, hold on. Okay, that's the last time you're going to interrupt me today without a contempt of court charge. Is that clear? Is that clear?
She gets me this entire time. No one has made her answer that.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means if you're agreeing with that, definitely means that you guys are lying against us.
So that means
Welcome back, everyone. Today, we're diving into one of the most intense courtroom showdowns you'll see. A return of classic sovereign citizen case with none other than Judge Oakley, known for her no-nonsense style. Right from the start, you can tell this is going to be chaotic, with motions flying, interruptions, and a battle of wills that tests patience, knowledge, and authority. Stick with me, because we'll break down every move, highlight where the law is misunderstood, and show exactly why courtroom procedure matters. By the end, you'll understand why this judge's firmness is not personal. It's about controlling the chaos.
Any argument you make from there, I'm going to deny because that's an unreasonable position you're taking. Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making...
What statement is that? I thought we were talking about Judge Green's SOS statement.
When you made this statement that you were setting aside my regular trial, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting that all aside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside on what you were doing.
Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
It's a dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt. Anytime I tried,
I am threatening you with contempt.
My objections on the make my case.
No, because Third contempt. Do not interrupt me. When I said your objections don't mean shit to me, is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence, and you say, I object.
Right here is where the tension starts building. Mr. Crucell is attempting to navigate a maze of motions, but Judge Oakley immediately establishes control. Notice how she forces him to stick to the facts, cutting through long-winded explanations. This is textbook courtroom authority. If you can't distinguish what's new from what's been addressed, the judge has to step in. For viewers, this is a fascinating look at the balance of patience and precision, how the courtroom process isn't just about rules. It's about managing chaos. And yes, we're already seeing the classic sovereign citizen strategy of overloading the court with paperwork and arguments.
I'm not denying the jury trial.
Especially with the jurisdiction, she's never once admitted on the why it's on the prosecutor to prove those things. There's all sorts of irregularities.
All right, let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows exactly that there is enough to show. You're supposed you need to sure.
Once again, you're not answering the question I asked. You just said you will not participate, and I asked, what do you mean by that?
Fair trial.
I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me getting all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
Statement I'd like to put on the record is that if whatever you would like to do from there, you can, because I don't until these things. Like I said,
Hold on. Is this statement preceding all these motions you filed?
all I
Okay, then let me make my ruling on all of them. I think there's a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
Speaker forcibly arrested Mr. Crucell while he was in Huron Township, but if a district court has jurisdiction over offenses that occur within the township, both civil and criminal, this is criminal against focus.
Did you appeal Judge Green's decision on that motion?
I'm prosecuting because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct?
Getting all involved.
I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to...
Now things get tense. Judge Oakley issues clear warnings about contempt. This isn't just lip service. Every time Crucell interrupts or refuses to follow proper procedure, she's calling out the behavior, imposing fines, and even hinting at jail time. This is an important lesson. Courtroom authority isn't arbitrary. It protects order, ensures fairness, and keeps the proceedings moving. And notice how she explains the difference between collusion and impartiality. She's walking a tightrope, maintaining authority while explaining legal concepts to someone clearly out of their depth. For the audience, this is where the drama really hits. Watching someone repeatedly push limits against a seasoned judge.
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay. Okay. Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant, because that's my job as the gatekeeper after the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Crucell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling.
Here's a moment that shows just how complicated self-representation can get. Cruzel's misunderstanding of previous rulings, defaults, and set-asides creates confusion that could easily derail the trial. Judge Oakley methodically explains the consequences, reinforcing her role as gatekeeper. It's fascinating to see how prior decisions, even those in his favor, are being manipulated into chaos. For viewers, this demonstrates a key principle. Legal procedure is cumulative. If you don't understand how past rulings interact with current motions, you can inadvertently make your case far worse. The judge's patience and clarity are critical here.
Do you want me to set aside those do you want me to set aside the default set-asides? Do you want me to reinstate those default judgments? Then I'll deny that motion. All right. You filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I. All right. The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
Essentially, yeah.
Okay.
Prosecutors.
Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent. Oh, excuse me, motion for judicial notice. What does that judicial notice of what?
Certain terms that everything that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used. Okay.
For example.
You use motor vehicle.
Okay. Motor vehicle's pretty much a term of art in our business.
Law differences between how it's being used. Absolutely.
Well, then you can make those arguments. But you can't tell her she can't use that phrase. Yeah, but I'm not the trier of fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument. Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these.
Pay attention to this section. Crucell objects repeatedly, often without legal basis. Judge Oakley explains why these objections don't count and why the jury doesn't need to hear about irrelevant motions. This is a classic courtroom teaching moment. Lawyers and self-represented individuals alike must focus on admissible evidence and relevance. The audience can see the importance of procedural knowledge, knowing when an objection is valid and when it's simply a distraction. And notice the dramatic tension. The judge maintains control, but Cruzel's persistence highlights just how easily courtroom norms can be tested by someone who doesn't understand them.
What this jury has to decide today is whether or not you violated the township ordinance on that date. Hold on. None of these legal arguments about whether or not I should recuse myself or whether or not you notice me up for constitutional rights, none of that has to go to that jury. And none of it's going to.
And that's another issue with the trial, and I emergency stop, motion to stop this.
I already ruled on that.
Certain back, acknowledge my motions for my next travel. Nothing to do.
Once again, I'm not trying to, I'm doing my function as a gatekeeper for a jury trial. I'm deciding what's relevant and what's not. And you can disagree with me that all day long. But we're going to do it, once again, we're going to do it my way. You can appeal me. I've been appealed before. I'll probably be appealed before I retire again. It's okay. That's the way the process is set up. I encourage you to appeal me. All right. I am open-minded enough to think that perhaps my mindset about your whole travel, whole thing, maybe that's all wrong. So a circuit court judge can tell me I'm wrong. But so far, and I've ruled this way a number of times on the traveling issue, nobody's ever appealed me to lead to a circuit court judge to tell me I'm wrong. But I'm open to that idea.
I said, well, you just keep, each judge has done the same thing. They just keep setting it aside. And acting like it doesn't even exist, not allowing me to make my case, which is violating my rights to be able to produce my case in my end.
What's your case that traveling doesn't mean operating?
I'm accepting the fact that this court's violated my due process rights in every way, the judicial bias and the fact.
All right, then appeal me. But today we're having a jury trial.
Stating an unlawful jury trial, and I think that weighty statement I need to get on the record.
All right, but hold on a minute. Once again, I want to know what that means. You're not participating.
Now we're entering the bias claim. Crucell attempts to claim judicial misconduct, but Judge Oakley immediately clarifies her impartiality. This is a pivotal moment. She balances firmness with fairness, explaining that disagreeing with rulings doesn't equal bias. For viewers, it's a crash course in how judges maintain objectivity under pressure. The emotional stakes are high. The courtroom is charged with frustration and misunderstanding, but Oakley consistently separates personal dislike from legal authority. This is exactly why seasoned judges are indispensable in keeping trials efficient and focused, even with highly combative defendants.
Or traveling in a motorized vehicle, that brings all those ordinances into play. That's my legal ruling. Appeal it. I encourage you to do that. But that whole traveling argument, dude, I've been through that argument a whole lot more than you have. Trust me, in the last 25 years, I've had that argument a lot. Traveling as you try to apply it meant you could not be stopped by the government from walking from one venue to another. But when we got motorized, then the rules kicked in.
Rulings from the American Jurisprudence side that literally stated that yes, first of all, you're allowed, and including automobiles, as long as one does not interfere with another's rights. And this has been something that's been established to be secure.
Then appeal me. Take that precedent and appeal me.
As well.
Okay, that's your right. I'm not trying to stop you from doing any of that stuff. I'm just trying to stop you from bogging down this jury with stuff that I've determined is not appropriate today.
Because just because you're determining it based off of what though? That's what I'm saying. All these things are relevant and they are accurate.
They're relevant to you. They're not relevant to me. I've made the decision. I have made the decision. I made that decision months ago and you didn't appeal that.
I mean, the process is working out.
Which is not an appeal.
Is an extreme, lawyer planning their agent. You can't do that.
Absolutely, I do that.
100%.
No. Listen to me. If I don't hold you to the same standard I hold her to, then I'm treating you differently than her. How is that unbiased and impartial? You've decided to engage yourself in this. You had free access to qualified, competent legal counsel. They're still here. There's one right there behind you. He's still ready to help you. You chose to do this yourself. That means you've got to know the court rules. You've got to know the statutes and the ordinances. You've got to know the rules of evidence. And if I help you through those lapses in your knowledge base, that's not fair to the prosecutor. Then I'm taking sides. And now I'm not going to let her walk all over you and try to trick you because you don't know some of those rules and statutes. But I am absolutely going to require you to know what you're doing because you've chosen to do it. That doesn't show bias. That shows impartiality.
There is no partial anything. I have the.
Once again, Mr. Crucell, that's your opinion. No, it's your interpretation of the facts. So you have to appeal my decisions. And look, dude, the fact that you're not in a jail cell right now shows how impartial I am.
When Officer Price literally pulled up to meet my wife days before any of this even happened and talked to us about the travel, even told me I was well within my rights, gave me every clarification that I was well within my lawful rights. This was all a retaliatory thing from the beginning. And then even when the chief called me, he even called me trying to overrate. I was like, what's that overrate? And then he goes towards the motor vehicle. And then he tried to get me to not pursue legal.
Here's where things get truly convoluted. Crusoe tries to reinstate previous defaults that had already been set aside, a level of legal misunderstanding that almost guarantees trouble. Judge Oakley systematically explains why this approach won't work, illustrating the consequences of self-representation in high-stakes trials. For viewers, this is both dramatic and educational. It shows how the court system is designed to prevent exactly this kind of procedural chaos. And it reinforces a recurring theme. Judges aren't being harsh or unfair. They are gatekeepers ensuring that only relevant and legally sound arguments reach the jury. What we've seen today is a masterclass in courtroom management. Judge Oakley methodically handles every motion, objection, and interruption with authority, clarity, and fairness, all while keeping proceedings on track. Crusoe's repeated misunderstandings, procedural errors, and challenges to judicial authority show why self-representation can be so risky. At the end of the day, the judge's rulings are consistent, factually grounded, and focused on what the jury needs to know. If you found this case as shocking and fascinating as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.